Ok.
Bom dia a todos, bom dia a todas. Fico muito feliz de estar com vocês nessa manhã. Estamos reiniciando aí a nossa terceira sessão, os nossos terceiro dia de trabalhos do nosso evento. Fico muito feliz de estar com vocês nessa manhã. Nesta manhã, pelo menos a nossa primeira parte da manhã será uma parte dedicada ao idioma inglês ou francês. E fico muito feliz de a gente poder contar com todos aqui que estão conosco nos assistindo nos diversos centros universitários espalhados aqui pelo Brasil e pelo mundo. I'm gonna now speak in English so everyone can understand, and as you can see on the subtitles, you can follow up in Portuguese with the live translation. And once again, it's my pleasure to have everyone here, and in the name of Escola Superior de Advocacia, Guarujá Núcleos, and in the name of the CNPq Research Group, Fundamental Rights, Environmental Society and Technology, connected to the Catholic University of Santos, Universidade Católica de Santos. It is my genuine pleasure to have you all here with us. Thank you so much for accepting to be with us in this event, and thank you so much for all your um, efforts to share and spread the word about this event. The purpose of this conference, this international conference, is to debate the role of the judiciary and the judicial system and the court systems, and especially in the line of the new technologies that are emerging just right now, and the thing that we can probably say that motivate us to organize all of these event is strongly connected to the generative artificial intelligence. The generative artificial intelligence is, without any question, the probably one of the very technologies on the edge just right now that probably will it's already changing the world, but not only it's changing the way that we perceive and understand the possibilities and the use of several historical institutions, as such judiciary court. The main concern of us here is how can we apply some of those technologies, so how can we apply some of those new technologies as generative artificial intelligence in the benefit of the humankind and the benefit of our society in general, and perhaps do not take a backslash with the use of this artificial intelligences or new technologies in general. Some of those technologies are already in use in Brazil and several other countries around the world, but the question is, can the machine perhaps deliver a proper decision? Can the machine deliver a proper petition to the judge? Can the machine ensure the possibility of the use of a better procedure in the line of artificial intelligence? With us in this session, this is the third session. The first session was last Saturday on the morning here, Brazil. The second session was on the Saturday, last Saturday, and we evaluate some fantastic labors of fantastic articles that were delivered by the contestants in this Congress. And this is the third question. This is the third session with some more expertise debating around the topic. The topic is quite fluid, every expert will deliver some of the insights connected to the main topic: procedure, courts, artificial intelligence, and the possibility of the use of the technologies in the line of all those topics and fundamental rights, of course. And I will keep this as light as we can, because the purpose here is singularly to debate, including the possibility of the use of or limiting some kind of generative artificial intelligence, or artificial intelligence in general, in the future, through some new laws to be debated and implemented in the countries in general, and even on a constitutional level of protection for the society in general. That's the main goal here. That's the main point of the debate here. Without any further ado, let me just say thank you one more time to every institution that helped on and supported on this on the possibility of this event to be real. And some of those institutions are Barcelona Technology School in Spain, Business School of Artificial Intelligence in USA, Centro de Estudos Sociedade e Tecnologia from Escola Politécnica da Universidade de São Paulo, here in Brazil, Comissão de Internacionalização do Programa de Pós-Graduação em Direito Político e Econômico da Universidade Presbiteriana Mackenzie, here in Brazil, Escola Paulista de Magistratura, here in Brazil, Escola Superior de Advocacia da OAB São Paulo da Segunda Região, here in Brazil, ETCAI, here in Brazil, Faculty of Law and the University San Clemente Odorisky in Bitola, North Macedonia. And here indeed we will have our Vice Rector, a dear friend, Dr. GORAN, that will share some thoughts on brief. We also want to say thank you to Global AI Ethics Institute, France and Croatia, based. And here we will have a member of the directory board of and founding member of this institute, Mr. ASSATO MOMCILOVIC. Global South in AI USA, CNPq Research Group, Políticas Públicas como Instrumento de Efetivação da Cidadania, connected to Universidade Presbiteriana Mackenzie, here in Brazil. CNPq Research Group, Teorias Sociais do Direito, connected to Universidade La Salle in Canoas, here in Brazil. INSPER University, International Group of Artificial Intelligence, based on UK, Bahrain and United Arab Emirates. Ministério Público Federal, here in Brazil. Stanford University in USA. Universidad Autónoma de Ciudad Juárez in Mexico. Universidad Católica de Temuco in Argentina. Universidad Nacional Autónoma de México in Mexico. Universidade Católica de Santos, here in Brazil. All those institutions across the globe share some role on helping and supporting these events somehow. I just want to say once again, thank you so much for everyone, and thank you so much especially for the people behind these institutions who helped to support these particular events. Thank you so much. And now I would like very much to have a dear friend, a fantastic person, a fantastic research, Mr. ASSATO MOMCILOVIC. As I mentioned, Mr. ASSATO MOMCILOVIC, he is one of the founders of the Global AI Ethics Institute, based on France and Croatia. And Mr. ASSATO MOMCILOVIC will share some thoughts about the topic. ASSATO,
Okay.
again, thanks so much for being here with us.
Thank you, Tiago, for this kind introduction. I will speed up a little bit because I was planning to be here until 2:20. I have my volleyball team expecting my participation in the next game, but I have one very small and efficiently organized presentation, I hope. So I'm going to talk about today about two topics, a little bit mention the Global AI Ethics Institute and to give the overview about what we are doing, and then to speak about something that is specific from Europe and that other continents can learn from, and this is EU AI Act. So as you're going to see, you can learn from it, from its contents, but also from the mistakes that were done in the process. Just to return to what you mentioned, interesting timing. I was just a few days ago giving one practical webinar in Croatia on the topic of general artificial intelligence and how to use some specific tools like the ChatGPT, which is obviously incredibly popular currently. And the next week I'm moderating the table about legal questions connected with AI in the global and ChatGPT. So I'm not going to spend too much time on me. You already announced me, so I think it's better to use in this time discussing the topic. And to start with the first slide, so this is an overview of the countries that are members of the Global AI Ethics Institute, and I can say that there are even a few new countries in the meantime because we are gaining members quite fast. But as you can see, we are distributed all around the world, which is actually the point, because we didn't want to be centralized and to represent only one school of thought. So what we are doing, there are few things that you can find on our page, but in general, we raise awareness on the cultural dimension of ethics applied to artificial intelligence. We are here, as also this conference is, to debate on ethics applied to AI and to talk about new perspectives, but also we like to explore a new global multilateral framework of AI normative global governance. Founders, I must mention my dear colleague Emmanuel, which is basically the spiritus movens behind this institution. We have executive and board member. I'm not going to mention all of the members. Tiago, you are one of them and very valuable one. Those are just the newest members, one that we accepted a few months back. So Jason Tan from Malaysia, Alex Antich from Australia, Azadeh Williams from Australia and United Kingdom. Also, we have advisory board that is here just to represent our diversity in the countries. So from South Africa, India, France, to Hong Kong. So we have a quite extensive network of professionals that we are cooperating and dealing with. But what we are actually doing, so list is relatively long, I would say. But for example, we have some journal articles that we are trying to write on a yearly basis. We have more than a few written in the last year or two. We have other publications, right? So one of very interesting ones is the second one, Can AI Be Sentient? Multiple perspectives on sentience and on the potential of ethical implication on the rise of sentience. And as we can see, we are, and many experts are just now debating that we might be here on this moment in time where we are kind of coming closer to the sentience, depending on the definition of artificial intelligence. And who knows, it might happen in the next maybe few years, or we might get closer. What we are doing also, a lot of conferences, a lot of talks, and I can say that only a small number of our actions are here. I think in the last 2 months I had maybe around 20 different events that I attended, moderated, lectured, or participated in some capacity. So there is a very vibrant, obviously, AI space currently on the global level. But what I'm going to do after this short overview, just for the for everybody who is listening, maybe they would like to kind of follow us or to join in certain capacity. This is going to be next maybe 10 or 12 slides that I'm going to spend some time. The Artificial Intelligence Act, or very famous European Union AI Act, which has been in progress. They've been working on it for a few years, and now it seems that it is finally ready to be published. So basically, what is visible, what usually we mention, and it is unavoidable in every debate on it, it is this a risk-based approach, how they say it, which is quite interesting. As you can see here, there are some projects, companies that you can put in some of those brackets. So from minimal risk to limited risk, high risk, and some of them are unacceptable risk. What in Europe is considered as unacceptable is not necessarily unacceptable in other parts of the world. So, for example, social scoring, mass surveillance, manipulation of behavior for the intent of causing harm. So this is something that we officially are not going to allow or to develop. But there is more in the EU AI Act. So I wanted to share then a few other things. So what is also important, not only visible, and especially is going to be interesting for everybody who is kind of law connected to this topic. So first topic is like the scope and the definition of AI systems, right? Because we need to have some kind of shared, common, and clear definition of AI systems. So this was the intention, at least, of this document. The second thing is the one that I mentioned, which is the most usual one. It's high-risk AI system classification, right? This risk-based system. But then we have also conformity assessment and certification, right? So it establishes, or it tries to establish, a regulatory framework for testing and certifying high-risk AI systems, requiring a conformity assessment. Also something that all of those topics, of course, could be discussed and debated at length, right, with the people who are just dealing with those topics. Fourth thing out of, let's say, 10 of them is also transparency and explainability, right? So we noticed here in Europe that there needs to be some kind of balance, right? You need to balance on one side interpretability, but on the other side advanced AI capabilities. So it's something that is, I would assume, currently happening more than ever in the past, making this topic even more relevant. Another topic that AI Act is dealing with is the data governance and quality, right? So they're kind of outlining requirements for the data, so that we need data to have a certain quality, which is always a question when you're feeding the models, right, with enormous amounts of data. What is the data quality? But then also, what is going to be the management of that data, and especially in the context of a GDPR in Europe, what is the protection of that data, right? So again, something that is tackled in the document. Sixth thing, and this is the aim, to hold both developers and users accountable in some way, right? So the question of accountability is always a popular one. If something goes wrong, who is going to be accountable? Who is going to suffer, let's say, the consequences if there are going to be some harm because of the AI systems that potentially were not developed in the right way. Seventh topic is the human oversight and autonomy. Again, balancing basically between human control on one side, and then this quest and this motivation on the other side to allow AI systems to perform autonomously, right? Because the full potential of AI is visible when they are, in some cases, perfectly autonomous, right? But sometimes then again, we are debating that it might not be the best idea. Eighth topic, privacy and surveillance concerns. Of course, again, balance between enabling innovation and protection of individual privacy that is recognized as a challenge, because we are pushing, and this is, I think, visible today more than ever, we are pushing the innovation out, right? So the OpenAI pushed their product, the ChatGPT, although according to some it was kind of still not ready as a product, right? It was not perfect. It definitely had a lot of things which hallucinated, and they're not corrected even now. Google responded, also pushing because of the market forces their product. So on one side we have innovation that is kind of requesting that things are developing and marketing them and are releasing them fast, but on the other side we have many issues that are kind of maybe not perfectly balanced. Again, international competitiveness, another topic of the AI Act, because they recognize, and I would say with very good reasons, that this is one critical aspect to consider. Because this international competitiveness is racing, well, some would say it's not even a race to develop general intelligence, it's a race to the bottom, or some would even be extreme and say this is like a fight to death, right? Depending on how dystopian you are. But again, a different topic. I'm sure that many of those things the following lectures are going to mention. And the 10th, I think this one is the last, is the implementation and enforcement. So in European Union, all the members like Croatia, France, Spain, Italy, everybody is going to have to establish the competent authorities, so the official bodies that are going to serve as enforcers of the AI Act and some kind of guarantee of the compliance, right? Also, one very interesting part we will see. In theory, it sounds in some aspects good, in some not. We are going to see what's going to happen. So maybe then to to summarize with one slide, that basically those are the concerns, right? Because we recognize a lot of concerns in these topics, which could be lessons learned, and in the sense that not lessons that we learned, but the lessons that you can learn from our mistakes. So basically, I would suggest that everybody from other continents and all around the world to consider this. And we have at least, I would say, 8 topics. So first is overregulation and compliance burden, which is going to happen, vague definitions and uncertainty in many points, competitive disadvantages that it might create for us on the global level, conformity assessments and certification as a specifically touchy subject, a chilling effect on the innovation. So we are not now innovators, and unfortunately we are believing that in the future, again, we are not going to be the most innovative, let's say, country or the group of countries in the world. Balancing transparency and intellectual property, again, topic that is, I think, rising on the popularity in the media. Fragmentation of the digital single market that it might cause, and maybe, again, connected with some of the previous ones, but very important, is insufficient focus on fostering AI innovation. So I would urge everybody who is dealing with that topic to be aware of all of those things about positive and negative aspects. So, respecting the time that I had planned, I think that this is it from my side, this short overview. For all of you that want to stay in contact, this is my LinkedIn profile. You can reach me there. This is my Medium profile. I'm publishing from time to time some of the opinion pieces there, so you can read them also in retrospect. Thank you very much for your time and for your attention. And Tiago, thank you very much for invitation to participate in this very interesting conference.
Thank you so much, Ato, for sharing your thoughts with us. You're always fantastic, and I'm pretty sure that some of those ideas are, I'm just sharing the screen with you here, and some of those ideas that you already just shared with us are amazing, and some of the main concerns when we are dealing with artificial intelligence in general. Ato, one of the things I know you have you have to go just right now. Hello, Goran. We can see your screen. Thank you. And one of the things that you just mentioned to us, Ato, is the over the necessity of over creating norms and laws to deal with artificial intelligence. I guess this is one of the main topics that we are here trying to discuss. Shall we laisser faire, laisser passer the situation concerning artificial intelligence, leave without any rule, or shall we put this with some strings and try to deal with this without any proper regulation, any proper kind of development on this. Thanks so much, Atto, for having attend this event, and thanks so much for your voice could be heard by everyone. We have about 200 people, 200 students just right now. Hear your thoughts. And once again, I know that you have an appointment, and please feel free to attend this other appointment that you have.
Thank you. See you. Bye bye.
Bye bye. And now, continuing on, moving on, I'd like to invite a dear friend, Dr. GORAN ILIK. Dr. GORAN ILIK is a dear friend from North Macedonia. He is a colleague of mine in the research that we could share in the Reggio Calabria University, the Mediterranean International Center for Human Rights, that we could develop some research in our postdoc. Goran is the vice rector of St. Kleminski Odoraski in Bitola, North Macedonia, and he is an amazing friend. He's a fantastic researcher, as a lawyer, as an academic, and I would like very much him to share some thoughts on this European perspective about law, courts, artificial intelligence, and constitutionalism, as he mentioned. Just once again, reminding everyone here, the purpose of this debate is to keep this as open as we can, so we can learn and understand the thoughts of the participants, the speakers of this conference. We can understand some different perspectives, we can understand some different points of view, we can understand a little bit better what we are dealing with, all this spectrum, large spectrum that it is indeed court, artificial intelligence, new technologies, and the reality in here Brazil, European Union, and Latin America. Without any further ado, let me invite for the spot here my dear friend Dr. GORAN ILIK. Dr. GORAN, how are you doing, my friend? You can turn your camera on, please, and the floor is yours.
Thank you very much, my dear friend. How are you? I hope that everything is fine there in Brazil.
Everything is all right, my friend. I guess your camera is off. I cannot see you, my friend.
Yes, because I have tried to open my PowerPoint presentation and maybe some technicalities arouse, so no problem. Okay, I will try to. Okay. I hope that you see the PowerPoint presentation.
We can see.
Yes. Thank you very much. Thank you very much. Thank you very much, my dear friend Tiago. I'm very happy at first to be invited by your side to participate in this great congress, which you are a lead organizer. It is shared with my university staff also, and I hope that some of my colleagues from Bitola University participate here or watch this great World Congress, I can stress. So yes, for today Congress, I decided to talk something about the rise of digital constitutionalism of the European Union, which is the topic which I am very interested in, especially in terms of judicial practice of the Court of Justice of the European Union, and also some regulation and directives which are delivered by the European Union. Why it is very important? Because, as we know, today we live in algorithmic society that can be defined as a set of practices and discourses involving hybrid links between public and private bodies, supported by a set of new data-driven technologies that create new layers of society management through own ways of knowing and acting. The challenge of digital constitutionalism is not to limit the social power of algorithms, it is very important to know, but to limit the social power that works through algorithms. Regarding the European Union evolution, at first, we have liberal constitutionalism, which had a vertical dimension where the power to restrict freedom is public, located in a certain territory and limited by the national constitutions. With the rise of the algorithmic society, and at a time when jurisdictions are becoming porous and irrelevant, public authority is no longer the only factor in respecting the basic rights and democracy. In algorithmic society, new sources of power are concentrated in multinational private actors. The rise of digital constitutionalism in the European Union means a codification of the EU Court of Justice commitment to protecting fundamental rights in the digital environment and limiting the power of online platforms by implementing legal instruments to increase transparency and accountability in content and data processing also. In general, such EU activity can be classified in several phases. At first, digital liberalism, judicial activism, and the third one yet to be developed and achieved is single digital market establishment within the European Union. Since the signing of the Treaty of Rome in 1955, the primary goal of the European Economic Community has been to establish a common market and bring economic policies closer together among the member states. The adoption of the Nice Charter in 2000 aimed to impose a strict obligation to respect the fundamental freedoms of the European Union, the free movement of goods, services, capital, and people. This liberal or this market approach was initially transposed in the digital environment. In the field of data and content, paradigmatic examples are these first directives, e-commerce directive and data protection directive, which confirms that European Union aim was and still is to ensure the smooth development of the single European market. The main objective of the e-commerce directive was to provide a common framework for electronic commerce and the smooth functioning of the internal market by ensuring the free movement of information society services between European Union member states. The directive establishes an exemption regime for internet service providers, understood as online intermediaries. The directive covers non-involvement of internet intermediaries in content creation, relieving them of the responsibility of transmitting or hosting illegal content to third parties, which is in accordance with the American model of so-called safe harbor principle established by the Communication Decency Act and Digital Millennium Copyright Act. The new member states may not oblige internet intermediaries to monitor the information transmitted or stored by users within their internet services, and at the same time, internet intermediaries are not required to establish facts or circumstances that reveal illegal activities carried out by the users. The internet intermediaries transfer the responsibility to their users, for example, in social media, through their terms of use, and thus transferring the responsibility to a private sphere, guided strictly by economic interests and paying attention to the risks of liability. So the connection and the relation is not vertical anymore, but it becomes horizontal. With the second mentioned directive, or data protection directive, the European Union decided to regulate the processing of personal data to address the challenges posed by the increased use and processing of data, in addition to the provision of new services and the development of digital technologies. This directive is based on the premise that the processing of personal data will serve humanity and aims to protect the fundamental right to privacy of data subjects in order to consolidate and ensure the smooth functioning of the internal market as an instrument for guaranteeing the fundamental freedoms of the Union. At the time, the actors operating in the digital environment were internet intermediaries that offered storage, access, and transmission of data over networks. There were no social media at that time, e-commerce markets, or other digital services. Thus, the role of internet intermediaries was quietly passive. The way in which these directives were implemented, as opposed to the regime of EU regulations, made it even more impossible to take a single EU approach to the issue of personal data protection in the context of the dynamic development of digital technologies. General Data Protection Regulation, fully effective since 25th May 2018, refers to data protection and privacy in the European Union and the European Economic Area. The primary goal is to give individuals control over their personal data and to simplify the regulatory environment for international business by codification of the European Union law. An economic entity or enterprise should be engaged in economic activity in order to be covered by this regulation. No personal data may be processed unless such processing is carried out in accordance with one of the 6 legal and basic principles set out in these regulations. At first, that is consent, then contract, third, public service, vital interest, legitimate interest, or legal obligation. Each EU member state shall set up an independent supervisory body to hear and deal with complaints, sanction administrative violations, and so on. Independent supervisory bodies from each member state should cooperate with other independent supervisory bodies, providing mutual assistance and organizing joint operations. The European Data Protection Board coordinates the independent supervisory bodies of the member states. Or Article 21 of GDPR allows the individual to object to the processing of personal data for market or non-market purposes. This means that the data controller must give the individual the right to stop or prevent the processing of personal data. An objection may not be lodged when processing the data only if it is implemented legally or officially, when there is a legitimate interest, where the organization needs to process data to provide the data subject a service for which it has applied, for example, and there are activities of public interest. With the implementation of the Charter of Fundamental Rights of the European Union, the European Court of Justice has begun to create legal doctrines to protect the rights of individuals in the context of digital technology, based on Article 7 and 8, referring to the respect for private and family life and protection of personal data. Those are the main articles. So, in the case of Google France, the European Court of Justice concluded that if an internet service provider did not play an active role in giving knowledge or control over the stored data, it could not be held liable for the data stored at the request of an advertiser unless it became aware of the illegal nature of the data or of the activities of the advertiser, for example, and at the same time failed to act in a timely manner to remove or disable access them. The Advocate General, Poare Maduro, concluded that search engine results are the product of automated algorithms that apply objective criteria to generate pages that are likely to be of interest to the internet user, and therefore, even if Google has a monetary interest in providing users with the opportunity to access more relevant pages, however, there is no interest in attracting a specific page to the user's attention. The Advocate General Maduro did not recognize the active role of this service provider. So, in the following case, named L'Oreal, the European Court acknowledged that offering assistance, including optimization, presentation, or promotion of sales offers, were not a neutral activity. However, the court did not reject the opinion of the Maduro in Google's previous case, Google France, but with this decision acknowledged the automated technologies have led to some service providers taking an active role instead of being passive providers of digital products and services. Then we have some other cases of European Court of Justice. That is the case Scarlett and Netlog, case of ProMusicae, case of Digital Rights Ireland, Schrems case, Google Spain case, etc., etc. So, based on these groundbreaking cases, which I mentioned, the European Court of Justice has entrusted search engines with the right to delete content online without removing the information. Hence, the data subject has the right to ask the search engine to delete the links to the information relating to him or her from the list of web results based on his or her name, of course, in the light of the fundamental rights under Article 7 and Article 8 of the previously mentioned Charter. Also, the European Court of Justice recognized the right to be forgotten on the Internet through the interpretation of the Data Protection Directive, or de facto application of mentioned Articles 7 and 8 from the Charter. At the same time, the court delegated to search engines the task of balancing fundamental rights in assessing users' claims for the right to be forgotten on the Internet. Those are the court landmark cases. The right to be forgotten is the right to have private information about a person be removed from internet searches and other directories under some circumstances. The concept has been discussed and put into practice in several jurisdictions, including Argentina, European Union, and the Philippines also. The issue has arisen from desires of individuals to determine the development of their life in an autonomous way, without being perpetually or periodically stigmatized as a consequence of a specific action performed in the past. In the EU context, the right to be forgotten was reflected by a more limited right of erasure in Article 70 of the version of the GDPR that was adopted by the European Parliament in March 2014 and which became EU law in April 2016. In September 2019, the European Court of Justice ruled the right to be forgotten did not apply outside of its member states. Artificial intelligence is used to describe systems programmed to act and work as humans. These systems are programmed for solving problems and improving themselves. Some of the most used data analysis today, such as search algorithms and recommendation engines, are AI-based technologies driven by machine learning and algorithm decisions. The intention and expectation of AI developers is that these machines will eventually be able to perform the same tasks as humans would. The use of AI technologies in various sectors and areas of life, such as health, education, work, social care, and law enforcement as well. AI can provide very important opportunities in the advancement of human rights across many areas, but AI being so progressively developing in circumstances where its possibilities are still not fully known as discovered. It is becoming obvious. It has the potential to bring huge progress, but also to undermine or violate human rights protection. Namely, the use of big data and AI can threaten the right to equality, the prohibition of discrimination, and the right to privacy. The violation of these rights can lead to risk of enjoyment of other fundamental rights and personal and political freedom as well. As artificial intelligence evolves, it magnifies the ability to use personal information in ways that can intrude on privacy interests by raising analysis of personal information to new levels of power and speed. The regulation on the AI development and use had been a hot topic within the European Union for quite some time. There have been several documents in the form of declarations, recommendations, communication, etc., directly related to the definition and regulation of the use of AI. In terms of EU communication and language, EU wording, AI is defined as systems that display intelligent behavior by analyzing their environment and taking actions with some degree of autonomy in order to achieve specific goals. One of the most important documents to directly tackle the harmonization of laws of EU member states is the Commission White Paper on Artificial Intelligence, named A European Approach to Excellence and Trust, where it is recognized that to address the opportunities and challenges of AI, the EU must act as one and define its own way based on European values to promote the development and deployment of AI. Following this paper, a year of highly intense debate with several different perspectives being loudly emphasized, the national and EU government bodies, private sector, civil society sector, etc. On April 2021, a proposal for harmonized rules on AI was issued, or popularly known as AI Act, that finally traced the way forward to a harmonized regulation regarding one of the most specific and controversial issues of the digital market. As stated in the proposal, its specific objectives are ensuring that AI systems place of the union market and use that are safe and respect existing law on fundamental rights and union values, to ensure legal certainty to facilitate investment and innovation in AI, to enhance governance and effective enforcement of existing law on fundamental rights and safety requirements applicable to AI systems, and to facilitate the development of a single market for lawful, safe, and trustworthy applications and prevent market fragmentation. However, it is a long way to go toward firmly settled and harmonized EU regulation on AI, and the issue is quite new, with quite an enormous scalability in its development, which makes it both super powerful and intimidating as well. So, considering the values the European Union is founded on, the aim of the development of digital constitutionalism is to provide higher level of protection of the civil rights and liberties, to mitigate the risks of illegal content spreading, to control the use of private data, and secure the tech development and innovation are done in a controlled, legally controlled environment that will not allow them to produce some sort of uncontrollable and illegal tech monsters. However, bringing a harmonized legislation will revolutionize the way in which technical companies operate as part of democratic societies, making the European Union a leading pioneer in this field. Following that way, other democracies, such as the United States, and for example, United Kingdom also, that are currently developing digital market policies, will follow the EU path and develop regulations aimed at protecting their citizens' rights. In that way, Western democratic world will develop a comprehensive approach towards the creation of harmonized policies in a way that embraces all the possibilities technological development is bringing to the societies, and at the same time providing highest possible level of protection of the values these societies are built upon. Thank you very much. I will not continue anymore. I think that is totally fine regarding the time frame of the Congress. So, Professor Tiago.
Thanks so much, my friend. Your insights were indeed amazing. And the thing is, my friend, how you deal with all these matters concerning all the European preoccupation concerning artificial intelligence and some of the challenges that you just mentioned, especially concerning the situation of identify what is artificial intelligence by all means, what's the big deal about artificial intelligence, and some of those challenges were indeed amazing, and some of those cases that you just mentioned are very thoughtful for everyone who is currently researching about this particular topic. You were mentioning about the right to be forgotten, and probably this is one of the main topics involving intimacy and fundamental rights and data protection and all those limitations that we can face it on. I was just reminding the Germany German decision about this particular topic involving that incident that occurs a little after the Second World War, and some of the guidance of this particular topic. I mean, the right to be forgotten. And thank you so much for sharing all this here. We here in Brazil were facing a new moment, just to FYI, my friend, because we are trying to establish some guidance as well, some governance as well in artificial intelligence. And perhaps this new law project, this new bill of law that we are here proposing and can solve some of those issues. And perhaps the most important, or one of the most important problems that we must face, not only here in Brazil, but worldwide, is probably that the people, the society in general, as I see, the society in general must understand and must see and must realize that they are doing at some point with some technological issue, some technological tool as artificial intelligence, and probably this will be one of the main things as far as I can see in the future to be debated, because due this generative artificial intelligence language, natural language, it's no longer possible easily to understand and to get that we are talking with a machine, and probably this will be one of the challenges for the future, my friend. Want to add something more?
No, thank you very much. You summarized the importance of my lecture and my speech, and also the speeches of the previous participants. So I have nothing to add anymore. It is sufficient. Yes, and we need to prepare our systems, our law with the new AI challenges, because as I started before, we cannot control the social environment, but we should to control the artificial intelligence. That's the most important, because what is the most important, especially with the chatbot GPS, because my students used the chatbot for their seminary paper, etc., etc. Maybe our colleagues from for scholarly papers also, which is legitimate, okay, but it's very important that the human intelligence is dominant. So ChatGPT or some other bots or artificial intelligence is totally dependent from us, from humans, and is on our side how we will create and construct our future. Thank you very much.
Thanks so much, my friend. Thanks so much for your university, and congrats once again for your work and all your efforts in the one of the main roles in your university. And naturally, of course, congrats once again for conducting all your work on JLIA. One amazing,
Thank you very much.
one
Thank you very much.
amazing journal, my friend. I hope to see
Thank
you
you.
soon.
Absolutely. Absolutely.
Bye bye, my
Have
friend.
a nice bye.
Well, let's go, keep going, and we here will have our third panel, and this third panel, we let me just arrange here, my friends, and we will have Mr. Badir Boussabat. Mr. Badir Boussabat, he is a fantastic person that I'd like to invite to share the floor here. I don't know how are you doing, but here in this session, this afternoon in European time zone, but here in Brazil it's morning. Do you want to proceed en français, or do you prefer to keep the first part of your exposition in English? How you will proceed, my friend?
Hello, Tiago. First of all, thank you for the kind invitation. Congrats again on this collaborative event. I think it's a very important time and event to share knowledge between us. Yes, indeed, I'm gonna start in English if you do not mind, and let's see how it goes. But English is perfectly well.
No problem. So I will introduce you a little bit better, my friend, Mr. Badir Boussabat. He's an advisor from companies and an enthusiast and expert in technologies and AI. He's currently based on Belgium, and he is a fantastic researcher, fantastic student, author of several books, speaker, and I could not say thank you enough for sharing some of these insights on his insights on this conference, because as you already know, the purpose of this event, the purpose of this conference is to debate a little about the three main goals, three main topics concerning new technologies, artificial intelligence, concerning fundamental rights, and concerning courts. And this Mr. Badir Boussabat, he as a person who is a third year of law, can reach all those three particular topics. As such was our last guest, Mr. Dr. GORAN ILIK, who kindly shares some amazing topics, amazing insights about the digital constitutionalism in European. Thanks so much, Badir, for your presence, and thanks so much for being here with us. We have currently audience of a little bit over, 200 people, or a little more from these. It's constant changing, but and be my guest, and the floor is all yours, my friend. Just one thing. When you will want to go to French, please let me know so I can change the language for the caption.
Sure, I will keep it in English, I think, to make it easier for you. So I will, yeah.
I know you're a multi-talented person and can speak in any language.
Thank you so much, Tiago, and thank you for organizing this brilliant event. And the idea of sharing knowledge, or let's say practices between Brazil and Europe, is a smart idea in my point of view. And let's make a follow up after the event, and I hope more cooperation will see lights in the upcoming days. So indeed, I'm going to start with something more concrete. I wanted to highlight several cases, some cases in Brazil and Europe that exemplify the intersection of fundamental rights, procedure law, and technology. And these cases highlight the complex legal issues arising from the intersection of fundamental rights, procedure law, and technologies in Brazil and Europe. You're going to see it illustrates the ongoing efforts to strike a balance between the benefits and risks associated with technological advancements, while at the same time safeguarding individuals' rights to privacy, which is a hot topic nowadays. These cases continue to shape legal frameworks and stimulate discussions on how best to address technology challenges presented by this digital era. Do you remember, I think, Thiago, you're the right person to remember this case about the WhatsApp case a few years ago. I think it happened 8 years ago or 7 years ago, when Brazilian authorities ordered a temporary nationwide block on the messaging app WhatsApp due to the company's non-compliance with a court order that requested at that time user data for criminal investigation. This case sparked a significant debate about the clash between privacy rights and law enforcement needs. This is why technology is, let's say, the right facilitator in order to forget about that clash between privacy rights and law enforcement needs, because actually both go toward the same direction. And this incident led to discussions on the balance between the right to privacy, freedom of expression, and the need of collective criminal investigations in the digital age. This is the first case we've heard about in Brazil. But there is also a similar case that happened in Europe regarding Google in Spain. It happened in 2014, and it has been known as like the right to be forgotten case. This ruling by the European Court of Justice established an individual's right to request the removal of search engine links that may contain outdated or irrelevant or even inappropriate personal information. And this case highlighted the problem, the tension between the right to privacy and freedom of information, as well as the challenges in regulating, framing, shaping the internet and search engine activities to protect individuals' fundamental rights. While going, let's say, through these two cases, we definitely notice that we have a lot, or let's say we have much in common. The challenges are the same, even though the approach of law is quite different. We all face the same situations. I've heard also about this case in Brazil, about the Marco Civil da Internet that took place 7 years ago, I think, or maybe 10 years ago. And it's about the Brazilian civil rights framework for the internet. I think this was a brilliant text because it's a comprehensive law that governs internet usage, data privacy, and freedom of expression in Brazil. In my point of view, it established principles such as privacy protection and intermediary liability. I guess in Brazil, from my understanding as a European, the law is considered a significant milestone in Brazil's legal framework for the internet, and it ensured fundamental rights that are upheld in the digital realm. But in my point of view, with artificial intelligence raging on in the market, we need to go forward. I'm thinking maybe about a global understanding, a global assessment, a global regulation linked to artificial intelligence, because it's all about being pragmatic. I've been going through 3 cases now that happened in Brazil, in Europe, and the problems are the same. We have a similar challenge we can deal with. This is why maybe global regulation would be the right answer to them, and this is why that kind of events like this event you organized, Tiago, with your colleague, is a perfect moment to get in touch with other colleagues, with other speakers, with other experts, in order to on a more frequent basis together and to talk about what people expect from us in the near future. But let's go beyond the cases. Let's go beyond the situation we have been facing in Europe and in Brazil about the digital era and about the artificial intelligence risks. Let's talk about the latest updates on procedural law and technologies that encompasses a range of advancements and developments that have occurred, that happened in the recent years. Let me share with you some key areas of updates. I think that artificial intelligence and technology play a major role in conducting the future of humanity, and the fundamental rights need to be protected. And this is why several key areas are, to me, pretty much important, like the electronic filing and case management systems. As you may know, many jurisdictions have adopted electronic filing systems, and that allows parties to submit legal documents digitally. This streamlines the process, reduces paper usage, and promotes efficiency in managing cases. And by the way, moreover, electronic case management systems provide improved organization, accessibility, and even search capabilities for legal professionals. It's important to understand that even in law, in the practice of law, we need to think about efficiency and high quality in management. We often, let's say, distinguish the law industry, if I may use this concept, and existing, let's say, conventional companies. Technology will apply to both, and this is why we need to, of course, enhance and exchange best practices between the private sector and the public sector, but also between what's going on, what has been achieved by the technology industry, by the tech industry, and the law field. The second area of update I wanted to talk about is linked to the online dispute resolution. It has gained actually traction as a means of resolving disputes online, often using technology platforms, let's say, empowered by artificial intelligence, because it can offer several advantages as increased accessibility and again reduce cost and faster resolution times. From my experience, and as I saw, and it has proven, let's say, particularly valuable in areas like e-commerce, consumer disputes, and even small claim cases. And we know how small claims cases are time-consuming for several experts in the law industry. We can even use artificial intelligence in legal research and analytics, and whatever the language we use, artificial intelligence is very good at translating, understanding the semantic elements. AI, as we all know, has revolutionized legal research and analytics, and advanced, let's say, algorithms. Artificial intelligence can now quickly analyze vast amounts of legal data, helping lawyers and judges even find relevant case law, statutes, and legal precedences. AI-powered tools also provide predictive analysis, assisting in assessing the potential outcomes of legal disputes. And one of the best illustration I can mention is about this donotpay.com. I guess you've heard about it. This donotpay.com initiative has been founded in the US, and it had tremendously, it had a lot of people in the US to better understand what's going on in terms of law practice and in terms of law updates. I think its membership, it is about $9.99 a month, something like that, and it had many, let's say, people financially excluded to, let's say, raise the dignity to better protect themselves with, of course, lawyers regarding these small claims cases. There's also another technology which is now a little bit less famous because of, let's say, the rise of artificial intelligence and ChatGPT. This is blockchain, and blockchain is a way or another one of the best decentralized and transparent platform ledger system. And I think that that blockchain has found applications in legal processes. We can mention smart contracts built on blockchain technology, and it also enabled automated and self-executing agreements. This is definitely an underestimated technology we need to think about, even though artificial intelligence, in my point of view, from my end, will be the most disruptive, the most impactful technology in the practice of law. Privacy and data protection. These areas, these topics are definitely a common ground on which we can, let's say, make successful cooperation flourish. And with the proliferation of data-driven technologies, the importance of privacy and data protection has become paramount. We've seen that in Brazil, we've seen that in Europe, legislative developments such as the European Union's General Data Protection Regulations, or the GDPR, and even the LGPD, so the Brazil's General Data Protection Law, have been enacted to protect, to safeguard individuals' personal data and establish guidelines for its collection. We need to keep in mind that that the solution, in order to better find our way to solve cases, problems linked to data, privacy, and so on, will rely exclusively on international cooperation. And if I may perform a parallel with Karl Marx's theory, it's very interesting because he said a few centuries ago that people will set free in a new future because we're gonna face such an international revolution. He talked about a specific revolution, but actually the revolution we have been facing for a while, is linked to artificial intelligence development. So artificial intelligence is a systemic tool that will have an impact on all sectors, even simultaneously, including law industry. So in my point of view, the real challenge now is to get closer to each other, to organize more events like today's event, and better exchange about artificial intelligence practices. This is definitely the most important challenge we have. It's not a technical issue. We do not lack inefficiency or lack development in AI development. We lack international cooperation, and definitely this is something we will able to tackle in the near future because of artificial intelligence. And you know why? In the beginning of this speech, this talk, Tiago suggested me to and offered me the possibility to talk both in English and French. And we definitely notice how technology is going to be helpful to offer us more opportunities to collaborate, and artificial intelligence will be, and we have the example of today, both the organization of this international conference and the introduction, the kind of introduction of Tiago mentioning the fact that we can use any language while delivering, I hope, a high quality conference. So thank you so much for listening, and if you have any question, please feel free.
Badir, your insights were amazing, and for all instance, I was not aware of the repercussion of some of those cases that you just mentioned here for us. I don't know if Michele probably is hearing us. Professor Michele, he's a dear friend of ours and from a long time, but I was not aware at all that that were so many repercussion from of some of these cases. And here, my friend Badir, let me share this first notice. We have here a new bill about liability over the big law tax companies, and this new bill is especially involving about the fake news and liability over fake news spreading, and the responsibility, the subsequent responsibility of these big law companies, Badir. So the thing is, in this week, we had an order from our constitutional court here in Brazil, Supremo Tribunal Federal, Brazilian Supreme Court, that how can I put this, void to the term to put the limitations on the spreading the possibility of the debate at some point from the Google company, from one of those other messengers, Telegram. Okay,
Oh, okay,
Telegram
okay.
and Google, both they had shared some thoughts about this particular bill, and the Brazilian Supreme Court voided this kind of manifestation as an act of anti-democratic speaker or something like that. It is at my side. I know and I understand that the debate must be spread from every sector, but as I can see, as far as I can see, it's a little concerning that our court is currently reaching currently limiting the possibility of the debate. And of course there is an agenda. Google own agenda. Of course, Telegram has its own agenda. It's completely normal to understand this, but to limit, to restrict the possibility of the debate, it's kind of I don't know how can I feel about this. I don't feel very comfortable at all because there wasn't any particular damage put on. There was simply an word spread on a blog from Google and a message spread on the Telegram for some I don't know, users of Telegram application. And that's some other case that I can share to you, my friend, that just happened in this very week. And this is quite connected with our general topic here, because we are dealing with artificial intelligence, we are here with liability, we are dealing with the court's role and the court's role in all constitutional system and its interactions between all those two other branches, executive branches and legislative branches, and everything's quite connected. This happened this week, I guess yesterday or the day before. I could not remind properly, but it's some quite news that I'd like to share to you, and that's the reason, one of the reasons for this Congress. But here, the purpose here is to debate some of these implications and the activism from judiciary at some point, with some matters that judiciary cannot understand much better than some person or some people in general, and try to face these challenges and try to overcome some of those challenges. Thanks so much for your insights here, my friend Badir. Thanks so much. The space is always open for your insights, for you here in Brazil, and be my guest to be here with us if you intend to be. And we will have our next participant of this session, this third session, Professor Micheli. Thanks so much, Badir. Any final thoughts?
Thank you so much for the invitation, and again, congratulations on this event, because again, what we have been facing, what we are facing is not a technical issue, it's a lack of collaboration in this kind of events that brings experts together to understand what's coming up and what we can create together in terms of artificial intelligence cooperation is definitely good news. So thank you again, Tiago, for this opportunity.
Thanks so much, Badir. I will turn to Portuguese just right now, and everyone who is currently watching on YouTube and on the other sessions can turn the translator from Portuguese to English, okay? Bom, vamos então dando continuidade aos nossos trabalhos. Eu só vou aqui fazer uma pequena alteração, vou pedir um minutinho apenas do tempo de vocês para a gente poder fazer essa alteração e já prosseguimos. Testando. Vamos continuar. Acho que agora está tudo ok. Ok, let's go. Pronto, alteração feita. Agora todos podem nos acompanhar pelos captions em inglês, pelo subtitle, pela legenda em inglês. E eu gostaria de dar continuidade aqui às nossas discussões dessa nossa manhã com uma querida amiga, professora Michele Assato. Professora Michele, eu só gostaria de compartilhar essa história, que é uma história muito bacana. Tive o privilégio, né, de conhecer a professora Michele em 2017, 2018. Desculpe se está ouvindo barulho de passarinhos, mas a minha casa ela é muito próxima de mato, de vegetação aqui da Mata Atlântica, no Guarujá. Então sempre temos muitos passarinhos aqui por perto. Então eles estão fazendo bastante bagunça. Não são passarinhos presos, mas são passarinhos soltos da natureza. Então eu conheci a professora Michele lá em 2017, quando eu tive o privilégio, o prazer e a felicidade de trabalhar junto com ela dentro de um estágio de docência na Universidade Presbiteriana Mackenzie. A professora Michele muito gentilmente me acolheu enquanto companheiro de estágio para os trabalhos junto à universidade, e eu descobri na professora Michele uma pessoa extraordinária e uma constitucionalista acima de tudo, e eu pedi mais uma vez, encareci e estou contando com o apoio da professora Michele pela expertise, pelo estudo, pela capacidade da professora Michele em direito constitucional, mas também como servidora pública do Poder Judiciário. E essas duas facetas, para mim, foram muito significativas no convite dessa especialista, dessa expert, dentro dessa temática que nós estamos aqui discutindo. Apenas para que todos tenham conhecimento, a professora Michele, ela é, como eu disse, professora principalmente em Direito Constitucional na Universidade Presbiteriana Mackenzie, e ela é uma das co-líderes do grupo de pesquisa CNPq, diretamente ligado à Universidade Presbiteriana Mackenzie. Esse grupo de pesquisa do qual eu também faço parte, o grupo de pesquisa, só me deixem aqui pegar o nome completo, Políticas Públicas como Instrumento de Efetivação da Cidadania. Esse grupo de pesquisa, como o nosso aqui, o Direitos Fundamentais, Ambiente e Tecnologia, ligados aqui à Universidade Católica de Santos, ele trabalha com diversas temáticas que são relacionadas também aos direitos fundamentais, e uma das temáticas que também a professora Michele tem trabalhado muito fortemente como professora são as temáticas ligadas à criança e à adolescência e a questões laterais envolvendo saúde, bem-estar desse grupo em particular em vulnerabilidade. Então, eu queria de verdade, mais uma vez, agradecer a professora Michele pela sua participação, pela sua presença nessa nossa manhã de sábado, sempre aceitando o nosso convite, se afastando um pouco da família, do filho maravilhoso que ela tem, do marido, do filho maravilhoso que ela tem, para poder estar aqui conosco nos nossos trabalhos dessa manhã. Professora Michele, muito obrigado, minha amiga, pela sua presença. O espaço é todo seu para suas considerações, para a senhora fazer as suas considerações a respeito dessa temática larga da qual nós estamos falando. Eu fiquei surpreso dessa repercussão aí do caso do bloqueio que o professor BADR comentou. Não sabia que tinha tanta repercussão assim no exterior. Vamos lá, professora, a palavra é sua, o espaço é seu.
Então, bom dia a todos, um prazer imenso estar aqui com vocês nessa manhã, agradecendo mais uma vez aí o convite do professor Tiago, na representação aí do Grupo de Políticas Públicas como instrumento de efetivação da cidadania. Eu trago hoje uma temática que também está ligada à minha atuação na universidade, porque eu sou coordenadora do Comitê de Ética em Pesquisa, e essas conexões, né, com a tecnologia tem sido um grande desafio para nós, principalmente, né, em pensar sobre a ótica da proteção de dados enquanto direito fundamental. Então, é muito bom estar aqui, essa oportunidade de poder compartilhar, né, desses assuntos com pessoas do mundo todo, e então isso é muito rico, e eu espero poder contribuir um pouquinho com essa discussão. Vou até iniciar aqui o meu cronômetro para não passar muito do tempo, e vou compartilhar uma pequena aqui apresentação com vocês. Um minutinho aqui enquanto carrega, né, que vocês me dizem se conseguem ver a minha apresentação.
Já está no sharing, mas ainda não consigo nos vê-la. Deixa eu ver se carrega.
O meu tá escuro aqui também.
Também está escuro.
Espera aí. Eu vou tentar compartilhar de outra forma, porque a janela não deu muito certo. Cinza, sempre um desafio aqui no compartilhamento, às vezes.
Não tem problema, minha amiga. O professor Goran também sofreu o mesmo problema. Ele compartilhou a tela e perdeu a câmera, coitado. Ficou sem a imagem dele e a gente teve que improvisar. Mas faz parte.
Às vezes acontece.
Tecnologias.
Ok, aqui no live, vamos ver.
Consigo vê-lo.
Deu certo?
Perfeito, professora. Pode seguir.
Então, tá bom. Então, o tema que eu trouxe hoje é a apreciação ética das pesquisas envolvendo seres humanos, a proteção de dados e a tecnologia. Então, vamos lá, né? A primeira grande reflexão é pensar, né, o porquê discutir a ética na pesquisa envolvendo seres humanos. Então, vamos voltar ali um pouquinho, né? A partir de 1948, a gente começa com mais seriedade, digamos assim, a discussão dos direitos humanos e o que eles representam, né, do ponto de vista de reconhecimento mesmo da nossa condição humana. Então, trazer essas garantias jurídicas universais que protegem indivíduos e grupos contra ações, omissões dos governos e que atentem contra a dignidade humana. Então, essa visão da dignidade humana, especialmente aí no pós-Segunda Guerra Mundial, começa a ganhar relevância nas discussões jurídicas. Bom, no que se refere às pesquisas, isso se dá especialmente pelas atrocidades cometidas durante a Segunda Guerra. Então, nós temos alguns exemplos, como os testes de hipotermia, né, onde se testava em seres humanos a possibilidade de resistência às baixas temperaturas, também em condições de pressão, né, o quanto que um ser humano poderia aguentar de altitude, testando, então, nessas pessoas para que os soldados já tivessem uma predisposição em relação ao que aconteceria com o corpo humano, né? Nem preciso dizer quantas pessoas morreram, quantas pessoas sofreram em relação a tudo isso. Bom, então, pós-Segunda Guerra, era preciso também pensar, né, o quanto que isso refletiria nas pesquisas agora em tempos de paz. Em 1962, então, em Seattle, né, a gente começa a discutir essa questão da ética em pesquisa, especialmente aí diante das dificuldades de atendimento a todos no que se refere à hemodiálise. Então, se nós tínhamos uma deficiência em relação ao tratamento lá nos Estados Unidos, era preciso, então, escolher de forma objetiva aqueles que seriam tratados e aqueles que, infelizmente, não poderiam ser. Então, essas discussões de forma objetiva em relação ao tratamento começam a ser discutidas por comitês de ética, né, que a gente ainda não chamava de comitê, mas que já tinha essa feição de comitê de ética. Em 1966, então, o Becker, professor aí da Escola Médica de Harvard, ele prepara um dossiê onde ele denunciava diversas infrações éticas, né, no que se referia aí à pesquisa e o tratamento das pessoas. Essas denúncias, elas se pautavam especialmente, né, na ausência de solicitação de consentimento dos participantes envolvidos na pesquisa, ou seja, essas pessoas eram submetidas à pesquisa sem que tivessem consentido com isso. Muitas vezes os riscos se sobrepunham aos benefícios, né, a utilização também de participantes vulneráveis, ou seja, pessoas com deficiência que tinham dificuldade de consentir, eram expostas a essa pesquisa sem saber, né, que eram participantes de pesquisa, e utilização, inclusive, de grupos placebos, agravando muitas vezes o tratamento efetivo daqueles pacientes. A partir disso tudo, né, começam a nascer, então, as normatizações da ética em pesquisa. Bom, no Brasil, a gente demora um pouquinho, né, às vezes, para fazer isso. Em 1996 é que a gente inicia as regulamentações da ética em pesquisa, né, fazendo nascer aí o Comitê Nacional de Ética em Pesquisa e os CEPs, que são os Comitês de Ética em Pesquisa localizados nos institutos de pesquisa e universidades, né, para que possam fazer essa análise ética das pesquisas. Qual é a amplitude disso tudo, né? O que as resoluções trazem? Bom, as pesquisas que devem ser submetidas ao Comitê de Ética são aquelas que envolvem direta e indiretamente o ser humano. Então, veja, é muito amplo, né? Envolvendo pesquisas em todos os níveis, de graduação, pós-graduação, pesquisas profissionais, e também todas as áreas de conhecimento. Nós, né, que somos aqui das ciências sociais aplicadas, muitas vezes, né, eu digo que existe uma lenda urbana dizendo assim, poxa, mas isso é para a área da saúde, né, nem sempre as ciências humanas vão trazer risco. Veja, a análise ética, ela parte do pressuposto que toda pesquisa envolve risco, em níveis, claro, diferentes, mas o risco existe, ainda que seja um risco mínimo, né? Então é muito importante que a gente tenha esse pressuposto. Toda vez que envolve ser humano, há um risco, ainda que seja um risco de cansaço, ainda que seja um pequeno constrangimento, mas sempre há um risco. Então, as ciências humanas e as ciências sociais aplicadas também se submetem aos comitês de ética. Então, para a gente entender um pouquinho como funciona essa normatização, né, os comitês de ética em pesquisa, eles são subordinados à Comissão Nacional de Ética em Pesquisa, que, por sua vez, se subordina ao Ministério da Saúde. Então, sim, né, as normativas, elas foram pensadas, né, iniciou-se aí a normatização a partir das ciências biológicas, mas a gente ampliou isso para ciências humanas e sociais aplicadas também. E temos também os comitês de éticas envolvendo a utilização de animais, né, nesses casos, eles são vinculados aí ao CONSEA, que, por sua vez, se vincula ao Ministério da Ciência, Tecnologia e Inovação. Então, são composições distintas. O que diz, né, a nossa regulamentação? Bom, no que se refere à ética em pesquisa envolvendo seres humanos, a gente tem a norma operacional 001, né, que disciplina questões mais técnicas, a resolução 466 de 2012 e a 510 de 2016, tudo do Ministério da Saúde. Então, a 466 foi a primeira, trazendo a regulamentação geral, aí da ética em pesquisa, e a 510, para que não houvesse ainda qualquer dúvida, né, trata especificamente da regulamentação da ética em pesquisa nas ciências humanas e sociais aplicadas. O que diz a 466, né? Ela traz diretrizes gerais para a participação de seres humanos em pesquisa, a necessidade inafastável, né, do consentimento livre e esclarecido. Então, nos comitês de ética, a gente analisa muito o chamado TCLE, né, termo de consentimento livre e esclarecido, porque a visão do comitê é sempre dar informação ao participante da pesquisa. Ele sim pode aceitar, participar, seja lá qual for o risco, mas ele tem que saber que eles existem, né? Então, é muito importante que esse consentimento ele seja o mais amplo possível, né? A análise dos riscos, os benefícios da pesquisa, os direitos do participante, né? De não ter custo em relação ao que ele vai participar, de que se caso houver algum problema, ele possa ser indenizado por eventuais danos que possam ocorrer, né? Responsabilidade e a capacitação do pesquisador e também o acompanhamento da pesquisa. Aquele que participa da pesquisa, que cede o seu tempo para participar de uma pesquisa, ele também precisa ser informado desses resultados. Quais são os benefícios diretos e indiretos para a sociedade, o que essa pesquisa gerou, o que o fornecimento desses dados para essa pesquisa contribuiu, né, para a sociedade. Então, é uma visão muito ampla em relação a isso. Então, aqui é 510, né, que trata exatamente desses procedimentos metodológicos que envolvam a utilização diretamente obtidos com participantes ou informações identificáveis. Uma coisa que às vezes eu percebo muito, né, que alunos e até mesmo professores nos argumentam, é assim, poxa, mas é só um forms, né, tudo bem, são forms, mas quando você coleta dados, né, de uma pessoa e utiliza esses dados, seja para que para o que for, é preciso que essa pessoa tenha consentimento, consinta e que tenha total ciência daquilo que vai participar, né. A 510, ela também traz algumas exceções, né, porque, como eu disse, a regra é sempre pesquisas envolvendo seres humanos, elas devem ser submetidas ao comitê de ética, mas a resolução 510 traz algumas exceções. Então, pesquisas de opinião pública, mas lembrando que opinião pública são aquelas questões mais objetivas, você gosta do iogurte de morango ou de banana, né, não são informações de natureza política, né, ideias e tudo mais. Informações de acesso público, então aqueles que a gente tem já de pesquisas já realizadas, né, de domínio público, pesquisas também censitárias, revisão de literatura, e o importante, a gente prestar atenção aqui, né, o que diz o parágrafo 1º, que inclusive os trabalhos de conclusão de curso também se inserem dentro dessa resolução. Pode parecer um procedimento burocrático, mas a gente tem que pensar, né, sempre na proteção aí do participante da pesquisa, né? Os comitês de ética em pesquisa, então eles têm um pressuposto, né, que não é ético permitir o que pode prejudicar. Então, se a pessoa for ser prejudicada de alguma forma, a pesquisa geralmente não é admitida, né? Mas dessa forma também não é ético proibir o que se pode beneficiar. É claro que as pesquisas estão aí, né, para melhorar a vida das pessoas e os comitês de ética em pesquisa, obviamente, não querem travar isso, né? Estamos todos aí no barco, visando, claro, o desenvolvimento da sociedade. Mas, em primeiro lugar, o participante da pesquisa. O olhar do CEP, então, ele é sempre um olhar para esse participante. Eu costumo dizer que é um exercício de empatia, né, se colocar no lugar do outro, para saber, né, se você, enquanto participante da pesquisa, né, o que você gostaria de saber, né, como que vai ser tratado, qual o processo de recrutamento, onde essas pessoas serão chamadas para participar da pesquisa, qual o perfil, os procedimentos, se eu vou receber um questionário, se eu vou responder um questionário, quanto tempo eu vou precisar dedicar da minha vida, né? É um questionário de 20 minutos, é um questionário de 2 dias, né? Acontece. Então, é preciso que as pessoas saibam para que elas possam consentir livremente, né? Os riscos, como eu disse, ainda que mínimos, né? Em caso de ocorrência, como que isso vai ser tratado, quais os benefícios diretos e indiretos, tudo isso está previsto naquelas resoluções que eu comentei. O TCLE, né? O termo de consentimento livre e esclarecido. Então, se ele traz todas essas informações, se a linguagem é apropriada ao público que se destina, tempo estimado, benefícios, privacidade, confidencialidade, e aqui eu já puxo aí uma notinha de rodapé, focando aí na nossa discussão da tecnologia, né? O que a gente percebeu, principalmente aí nesse período pandêmico e pós-pandêmico, né? A tecnologia também veio para ajudar, e não dava para parar, né? Não dava para parar a vida, não dava para parar as pesquisas, não dava para parar tudo. Então, muitas pesquisas, quando possíveis, elas foram transformadas em pesquisas digitais. Então, as pessoas eram chamadas para responder um questionário que antes era feito pessoalmente, passou a ser feito agora por instrumentos digitais. Porém, algumas coisas, elas deveriam ser observadas. Então, se eu tenho um TCLE, né, onde o participante da pesquisa consente com aquilo, agora em formato digital, né, a gente precisa ter um instrumento adequado para que ele possa consentir antes de abrir o próprio questionário, para que ainda assim ele tenha acesso ao pesquisador. Então, se eu tiver algum problema, se eu tiver alguma dúvida, eu preciso ter acesso ao pesquisador para que eles tirem a minha dúvida, sempre nessa visão do consentimento livre e esclarecido. Além disso, se eu estou numa entrevista, né, numa entrevista online, onde o pesquisador não está ali comigo, eu tenho a garantia de que esses meus dados, eles vão ser guardados de forma apropriada. Então, o pesquisador, ele se responsabiliza a manter esses dados sob seu controle e sigilo por um prazo mínimo de 5 anos, né, o que diz a resolução. Mas ele tem um local adequado para que seja gravado, porque muitas vezes eu estou fornecendo dados sensíveis, e a gente já vai falar um pouquinho sobre isso, dados sensíveis ao pesquisador, e ele precisa se responsabilizar por uma guarda segura daquilo que eu estou dizendo, né? Vamos lembrar que se houvesse dúvida em relação a fundamentalidade da proteção de dados, né, do direito fundamental à proteção de dados, nós temos uma emenda constitucional recente que insere a proteção de dados lá entre os incisos do artigo 5º, para que não restem dúvidas de que esses dados, né, fazem parte aí dos meus direitos fundamentais. Mesmo aqui, né, quando a gente fala em utilização de imagem e voz, então é importante que esse pesquisador se responsabilize pela guarda fiel, né, daquilo que eu digo, da minha imagem, de como eu me manifesto em relação a determinado assunto, né. Então, todos esses instrumentos também de coleta de dados, eles têm que estar à disposição do Comitê de Ética para que faça análise também desse proceder. Uma coisa que eu não falei ali, que estava no slide seguinte, é também o termo de assentimento livre e esclarecido. Então, todos aqueles participantes da pesquisa, como crianças ou pessoas com deficiência que talvez não possam consentir livremente, seja pelo seu desenvolvimento incompleto, no caso de crianças e adolescentes, ou das pessoas com deficiência, eles assinam também um TALE, né, o que a gente chama termo de assentimento livre e esclarecido, porque ainda assim, né, são pessoas e que têm que consentir, né, ainda que elas não tenham a sua capacidade civil totalmente completa. Mesmo uma criança pequena, né, você tem que perguntar a ela, né, enquanto sujeito de direito, se ela quer participar dessa pesquisa. Não basta que seus pais digam que sim, ela pode participar da pesquisa, ela tem que dizer que quer participar da pesquisa. Então, mesmo aquelas pesquisas, né, com criança pequenininha, de como que ela desenha, de como que ela se manifesta em relação a determinado assunto, ela tem que consentir, né, porque a gente parte também desse pressuposto de que é uma pessoa e que tem a sua própria vontade, que a sua voz deve ser respeitada, né? E algumas reflexões aí desse cenário da tecnologia. Vamos lá, né? A Lei Geral de Proteção de Dados, que é a Lei 13.709, ela traz alguns pontos, né, a serem observados quando se trata de pesquisa acadêmica. Então, lá no artigo 4º, ela diz que não se aplica, né, o tratamento de dados, as especificidades da lei, né, o tratamento de dados acadêmicos, mas ela faz uma ressalva, aplicando-se a esta hipótese os artigos 7º e 11º da lei. Quando a gente vai lá no artigo 7º, ele diz, né, o tratamento de dados pessoais somente poderá ser realizado nas seguintes hipóteses. Mediante meu cachorrinho se manifestando aqui. Mediante fornecimento de consentimento pelo titular. Então, vejam, né, mesmo a Lei Geral de Proteção de Dados, quando se trata de pesquisa para fins acadêmicos, também ressalta a necessidade de consentimento daqueles que participam, né? E no 11º, mesmo quando ele faz a ressalva, né, que o tratamento de dados pessoais poderá ocorrer, né, sem fornecimento de consentimento, ele diz que só nos casos, né, de realização de estudos por órgãos de pesquisa, mas garantindo sempre que possível a anonimização de dados pessoais sensíveis, né. O que a gente percebe muitas vezes é a utilização da pesquisa de prontuários médicos, mas aí é necessário que a pessoa não possa ser identificada, né, então é não identificado ou não identificável, porque às vezes também, né, são tantas as características, não tem o nome, mas você consegue identificar quem é. Então, é uma preocupação muito interessante sobre a não exposição, né, da pessoa e a proteção dos seus dados, mesmo para fins científicos, né. E aí, quando a gente fala em dado pessoal sensível, o próprio artigo 5º da LGPD ele vai nos trazer quais são esses dados, né? Então, fala sobre dado pessoal sobre origem racial ou étnica, convicção religiosa, opinião política, filiação a sindicato, organização de caráter religioso, filosófico ou político, dado referente à saúde e à vida sexual, dado genético e biométrico quando vinculado à pessoa natural. Então, vejam, né, ainda que sejam formes, se eu for tratar de algum desses dados sensíveis, né, em relação ao participante da pesquisa, eu preciso sim da submissão ao comitê de ética e o consentimento expresso da pessoa para a utilização desses dados, né? Sempre lembrando que a resolução 510 de 2016, ela diz que sempre deve ser preservada a identidade daquele que participa da pesquisa. E aí, só para trazer um pouco de atualidade aí para a nossa discussão, acho que ontem, né, foi confirmada, ontem ou anteontem, foi confirmada a sentença de primeira instância que condenou, né, o metrô de São Paulo naquela questão do reconhecimento facial das pessoas sem o consentimento, né, e aí tem um trecho da sentença onde a juíza, e eu considero que adequadamente, né, ainda que não seja aí uma pesquisa para fins acadêmicos, mas eles reconheceram que era uma pesquisa com finalidades comerciais, porque eles identificavam, né, como a pessoa reagia a determinados anúncios, se era uma feição de contentamento ou descontentamento, né, ela considerou que se tratava de coleta de dados sensíveis, né, porque era uma coleta de dado biométrico, reconhecida aí como dado sensível na LGPD, e considerou então inadequada, condenando aí, né, o metrô de São Paulo uma indenização por dano moral coletivo no valor de R$100 mil. Então, o quanto que nós temos aí de desafios, né, seja nessa análise ética do uso da tecnologia para pesquisa, seja para fins acadêmicos, fins comerciais como um todo. Acho que sim, estamos aí no caminho acadêmico dessa discussão, que é tão rica, né? Meu tempo já foi. Muito obrigada aí a todos, né? Um prazer imenso novamente poder compartilhar desses temas, e acho que a gente ainda tem muito que andar, e eu costumo repetir que a pesquisa só tem sentido se ela for feita coletivamente, e o professor Tiago tem feito isso com maestria. Muito obrigada a todos que me escutaram.
Obrigado, gente. Então vamos lá de novo, só refazer essa fala inicial que eu fiz agora rapidamente. A professora Michele fez uma excelente exposição. Obrigado aí, gente, por ter avisado que eu estava sem som. Eu queria agradecer muito a professora Michele, falou da importância da pesquisa científica para o desenvolvimento mesmo das pesquisas relacionadas a direito, a tecnologia, a ciências sociais aplicadas. Então, isso foi muito importante, acredito eu, para as pessoas que estão efetivamente lidando e trabalhando com tecnologias relacionadas aí usando das tecnologias para poder desenvolver a sua pesquisa. E aí eu mencionei até a Noemi, do nosso grupo, que estava desenvolvendo alguma questão dentro desse sentido, e parece que a palestra da professora Michele foi bem direcionada para isso. Eu queria agradecer mais uma vez a professora Michele por isso. E a notícia que a professora Michele trouxe, nesse caso desse julgamento histórico da coleta de dados feita pelo metrô em São Paulo, às vezes por mais bem intencionado que seja a coleta de dados, tem que ser feito com alguns cuidados e tem que ser feito, acima de tudo, como diz a nossa Lei Geral de Proteção de Dados, com o consentimento das pessoas. Eu me recordo desse caso da coleta de dados, professora Michele, e acredito que a senhora também deva se lembrar da analogia que eu vou usar, do filme Minority Report, do Tom Cruise, que era a mesma dinâmica na tecnologia futurista. Para quem não assistiu o filme, está perdendo um filmaço, mas o filme Minority Report, o cidadão ele andava pelas ruas e havia reconhecimentos biométricos a todo momento, íris, rosto, e os merchandisings eram direcionados à pessoa a partir desses dados biométricos. Então, assusta a gente falar certa monta esse tipo de situação. Por um lado, pelo menos eu penso que é um pouco assustador essa privacidade ser violada dessa forma, mas por outro lado a gente já vivencia certa monta essa situação quando a gente está navegando no Facebook, no Instagram, no LinkedIn, no YouTube, porque já tem acesso a esses dados para poder fazer direcionamento de merchandising, de adwares para o nosso perfil específico. Então, de uma certa forma, nós já vivenciamos isso, pelo menos no mundo virtual. Agora, no mundo real, a gente acaba percebendo essa situação aí aparecendo. Ô Flavinho, obrigado. Acho que a gente conseguiu resolver, querido. Era um probleminha aqui de áudio no meu computador, mas eu acho que a gente já conseguiu resolver. Acho que todos agora estão ouvindo. Embora a Noemi me alertou, o áudio de novo está baixo aqui no meu computador. Infelizmente, não sei o que pode estar gerando esse áudio baixo aqui no meu computador. Mas tudo bem. Seguimos aí que já estamos encaminhando para o encerramento dos nossos trabalhos. Então, eu queria dizer para todos que todos esses expositores dessa nossa manhã de sábado, na nossa terceira sessão, no nosso segundo dia de evento, nossa terceira sessão, nosso segundo painel de especialistas, foi, acredito eu, bastante enriquecedora para que a gente consiga ter uma compreensão um pouco mais abrangente do que nós estamos lidando quando falamos de direitos fundamentais, de tecnologias, de uso dessas tecnologias nas vivências humanas e principalmente da implicação do uso dessas tecnologias no nosso enfim, dia a dia, rotinas, tanto da academia quanto do poder judiciário. Eu acredito que tenha servido bastante para a gente poder instruir atividades futuras daqui da nossa parte. Professora Michele, eu queria pedir que você fizesse algum último comentário para a gente poder fazer a conclusão dos nossos trabalhos dessa nossa manhã, agradecendo mais uma vez a você, professora, agradecendo ao grupo de pesquisa que você lidera junto com o professor Ismânio, que está aqui conosco, bem representado no Conselho Científico aqui do nosso trabalho. Queria agradecer à Universidade Presbiteriana Mackenzie, sempre uma parceira nossa de trabalhos e de atividades, e mais uma vez reiterando que pesquisa, atividades acadêmicas a gente não consegue fazer de forma isolada, por isso que a gente sempre traz tantas instituições de pesquisa como a gente apresentou para vocês no começo dos trabalhos, que são todas essas envolvidas aqui nas atividades. Professora, muito obrigado, a palavra é sua para suas considerações finais.
Então, não, só me resta agradecer mais uma vez, né? É sempre muito bom compartilhar as nossas angústias aí acadêmicas, aproveitando que estamos aí na véspera do Dia das Mães, né? Outro dia eu vi uma reportagem que dizia que depois de 20 cliques, né, as redes sociais, elas sabem mais de você do que a sua própria mãe. Então, olha, como isso é assustador, né? Mas é muito bom poder pensar junto. E eu sempre falo para os meus alunos, né? Quando a gente escolheu fazer o direito, e eu digo assim, procurem isso dentro do coraçãozinho de vocês, com certeza foi com essa intenção de fazer o mundo um pouquinho melhor, né? A gente reconhece o quanto que o direito ele é essencial aí nas estruturas sociais, políticas e tudo mais, então vem essa sensação de poder de alguma forma contribuir para um mundo melhor. E eu, como eu sempre digo também, a gente luta com as armas que tem, né? E as nossas na academia é justamente colocar luz sobre determinados assuntos, e agradeço muito aí ao professor Tiago pela luta conjunta, e espero que a gente possa compartilhar desses momentos com mais frequência. E obrigada a todos aí que se dispuseram a nos escutar um pouquinho no sábado de manhã.
Eu que agradeço, Michele. Você é sempre uma excelente expositora, uma grande amiga que abraça aí as ideias da gente, então somente gratidão a você. Queria só dizer mais uma vez aí a todos que nós temos aí um terceiro dia de atividades a partir do sábado que vem. Queria então já deixar convidado para o nosso terceiro dia de evento, nosso terceiro dia de trabalhos e de compartilhamento de informações. E eu não posso também deixar de mencionar, a professora Michele bem lembrou, nós temos hoje uma data muito importante aqui no Brasil. Hoje é o dia da abolição da escravatura aqui no Brasil, então é uma data muito significativa, o 13 de maio, para todos nós, o dia da lei brasileira, a Lei Áurea Brasileira, que foi estabelecido ao fim da escravidão em 1888. Então a gente fica absolutamente feliz também de estar realizando um evento numa data tão significativa, discutindo direitos fundamentais efetivamente nessa data. E não obstante, hoje, o dia 13 de maio, amanhã 14 de maio, coincidentemente também, Dia das Mães, professora Michele, como mulher, como mãe que você é, por favor, me permita deixar o meu carinho a todas as mães que nos assistem, que nos acompanham, as nossas mães, a minha mãe. A gente fica muito feliz de ter vocês aqui conosco, compartilhando esse conhecimento e, como eu disse, privando um pouquinho da família, privando um pouquinho do convívio do filhote lindo que você tem, e para estar aqui conosco, compartilhando, fazendo ciência efetivamente. Querida, um beijo grande para você. Saudade, precisamos nos ver mais presencialmente.
Com certeza.
Até
Obrigada, viu?
Eu que agradeço. Até a próxima a todos. Nos vemos então no nosso próximo sábado, no nosso último dia de evento. Então, agradecendo a todos aí a paciência, a oportunidade de a gente compartilhar esses eventos, todos que nos assistiram ao longo desses 2 dias de trabalho, já com 3 sessões realizadas. Um abraço a todos.